Okay, I will give you some money, but do I have to pay taxes on it? In Italy and in Europe, where wealth concentrated on the elderly will inevitably change hands in the near future, the latest Italian legislation is interesting. We are talking here about donations, both small and large, of companies or money, which are often made by an elderly person. Thus, what the Corte di Cassazione most recently in its ruling number 7442 of 20 March 2024 stated, namely that there is no tax liability for all indirect or informal donations between parents and children, will soon become definitive. Both informal donations, including money given brevi manu or by check, and indirect donations will become tax-free, at least up the amount of the deductibles. With regard to companies, the transfer in favor of descendants and spouses is not subject to inheritance and gift tax if the beneficiaries, who have the jure control of the company or reinforce the already existing control, continue to carry on the business activity or otherwise remain owners for a period of not less than 5 years from the date of transfer. This applies to companies throughout the European Union, provided that the company law of the countries in question is uniform. Even in the case of a trust, no gift taxes will be due given the tax neutrality of the donation, representing the initial act of endowment and the outgoing transfer of assets from the trustee to the beneficiaries. On the payment of taxes, what is new is that they are self-assessed. This practice always surprises my non-Italian interlocutors, and in our country it is now also extended to inheritance and donation tax. Basically, the tax is calculated on the basis of the declaration, directly by the person liable for payment. It must be settled within 90 days from submitting the declaration. It can also be paid in installments with a down payment of 20% and then up to 12 quarterly installments. Dear aunts and uncles, you can be now generous with your nieces and nephews without tax worries.